because when that coordination is missing or when it is misunderstood, the result is delays, confusion, unnecessary conflict at exactly the time when families can least afford it. These are the moments when someone already dealing with incapacity, medical issues, or stress, and instead of things working smoothly, they are stuck in a bank trying to convince someone to accept a document that does not apply. There is a very common and very disruptive misunderstanding that comes up in estate planning, and it usually doesn't show up until something has already gone wrong. By the time it surfaces, families are frustrated, financial institutions are refusing access, and someone is pointing fingers trying to figure out what failed. This is one of those situations where the problem isn't a bad document, it's a misunderstanding of how the documents actually work. A while back, I received an email from someone acting as an agent under a power of attorney. She also happened to be a licensed attorney, but not in estate planning, which made the tone of the email even more surprising. She was angry, direct, and very confident in her conclusion that I had screwed up the power of attorney document because it did not allow her access to her friend's bank account. From her perspective, the analysis seemed simple. She had a valid power of attorney, she presented it to the bank, and the bank refused to give her access. Therefore, it had to be the fault of the attorney who put everything together. That document had to be defective. The problem had nothing to do with the power of attorney. The account she was trying to access was not owned by the individual. It was titled in the name of the trust. And that distinction is everything. A power of attorney gives an agent authority to act on behalf of an individual with respect to that individual's assets. Once an asset is transferred into a revocable living trust, it is no longer owned by the individual in their personal capacity. It is owned by the trust. And that means the rules governing access to that asset are no longer controlled by the power of attorney. They are controlled by the trust. This is the part that most people never get clearly explained by other attorneys. A power of attorney is not a master key. It does not override ownership. It does not give you authority over everything just because you have the document in your hand. It only works within the scope of the assets that are still owned individually. So when someone walks into a bank with a power of attorney and tries to access an account titled in the name of the trust, the bank is going to say no. Not because they're being difficult and not because the document is defective, but because the person standing in front of them is using the wrong authority document for that particular account. Probate attorneys don't benefit when people truly understand probate and try to avoid it. Probate attorneys profit when people use wills instead of trusts. If you weren't told the benefits of avoiding probate, then leave a comment and like and subscribe if you want more of this information explained in plain English. In this situation, the correct path forward was not to argue with the bank or question the validity of the power of attorney. The correct approach was to use the trust. Specifically, that meant presenting the trust document showing that she was the named successor trustee, and in this case she was, along with the documentation required by the trust to establish that the original trustee, her friend and my client, was incapacitated. In most cases, that means one or more doctor's notes or statements confirming incapacity. Once those pieces are in place, the successor trustee steps into authority and can manage the trust assets, including bank accounts titled in the name of the trust. That is what actually unlocks access. That is the correct key. Trying to use a power of attorney to access a trust account is like trying to use your car key to unlock the front door of your house. When it doesn't work, the problem is not that the key is defective. It's that you're using the wrong key for the wrong lock. You can stand there all day, you can jiggle the key, you can get frustrated, and you can even blame the person who gave you the key. But none of that changes the reality that the key you have does not match the lock you're trying to open. What makes this issue more frustrating is that it is not uncommon. People assume that a power of attorney is a universal access document that works across all assets, regardless of how those assets are titled. That assumption is simply not correct, and it leads to exactly these kinds of problems at the wrong time. Financial institutions are not being difficult when they deny access in these situations. They are following the legal structure of ownership, which is exactly what they're supposed to do. If they allow someone with a power of attorney to access a trust owned account, they would be ignoring the actual ownership of that asset and expose themselves to liability. This is why coordination matters in estate planning. It is not enough to have a power of attorney in a trust sitting in a folder somewhere. The plan has to be structured so that the right people have the right authority over the right assets under the right circumstances. That includes making sure assets are properly titled, making sure the correct people are named in the correct roles, and making sure those people understand what documents they are supposed to use and when. Because when that coordination is missing or when it is misunderstood, the result is delays, confusion, and unnecessary conflict at exactly the time when families can least afford it. These are the moments when someone already dealing with incapacity, medical issues, or stress, and instead of things working smoothly, they are stuck in a bank trying to convince someone to accept a document that does not apply. If you want to understand how to set this up properly so your family is not stuck dealing with these issues, you need to understand not just what documents you have, but how they actually function in the real world. That is why I put together a free course that walks through how trusts, powers of attorney, and asset titling all work together as part of a coordinated plan. You can access this free course at freetrustcourse.com. Again, that's freetrustcourse.com. It will walk you through these concepts in plain English so you can make sure your plan actually works the way it's supposed to when your family needs it most. And again, I am Jeffrey G. Mersace, the Plain English Attorney, and as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.